None. I'm going to call this Friday, March 11th, 2016 meeting to order with a roll call. Judge Christopher Kraft,
Present by phone.
Judge Lauterbach,
Present by phone.
Judge Hudson,
Present by phone.
Judge Harvey is absent, Judge Ford, or excuse me, Stancil Ford,
Present by phone.
Linda Byford,
Present by phone.
Veronica Thornton.
Present.
We have met the quorum. Now I'm going to read the statement of necessity into the record. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body other than a state debt issuer, the governing body must file such determination of necessity, including the recitation of facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at that meeting requiring timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Private Probation Services Council. The purpose of today's meeting, with some members attending by teleconference, is to discuss the agenda as noticed on the website earlier and the scheduled rulemaking hearing. The notice of the March 11, 2016 meeting of the Private Probation Services Council was posted to the Private Probation Services Council website on February 23, 2016. Do I have a motion from one of the members to adopt the agenda?
I move we adopt the agenda. I second the motion.
Could I have the names when you do this by phone? I'm sorry, guys.
Judge Lauterbach makes the motion.
Lauterbach.
Seconds.
Who was the second?
Judge Kraft.
Judge Kraft, thank you. And call for the vote on that. Judge Kraft,
Aye.
Lauterbach, Hudson,
Aye.
Ford,
Aye.
Byford,
Aye.
Thornton.
Aye.
Motion carries unanimously. Motion to adopt. Is there a motion to adopt Robert's Rules of Order?
I move we adopt. This is Judge Lauterbach. I move we adopt the Robert's Rules of Order. Second. Stancil Ford.
Okay. Is there any opposition? Hearing none. I'm going to call a roll call vote. Judge Kraft,
Aye.
Judge Lauterbach, Judge Hudson,
Aye.
Stancil Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton.
Aye.
Motion passes by unanimous vote. We are going to send out conflict of interest forms for signature to the members who are not present, and Mr. O'Brien got the conflict of interest form to Ms. Thornton here today. Excuse me, I just need a moment. Sorry, I think I have that cold too, Judge Kraft.
Yes.
Next on the agenda is the election of officers. Are there any nominations from the members?
I nominate Judge Kraft as the chairman. This is Judge Lauterbach making the nomination. Second. This Stancil Ford. Judge Kraft does not strenuously object.
Okay. Um, is there any objections? Hearing none, I'm going to call a roll call vote. Judge Kraft, Judge Lauterbach, Judge Hudson, Stansel Ford, Linda Byford,
Aye.
Veronica Thornton.
Aye.
Next, we will call for a nomination for vice chair.
Yes, this is John Hudson. I'd like to nominate Klein Lauterbach. Judge Kraft seconds.
Okay.
Oh, good morning. This is Hugh Harvey, RMLA.
Okay. Now we have a full membership of the Private Probation Services Council. Thank you for joining us, Judge Harvey. We're very glad to have you.
One of the better phrases known in the legal system, default judgment. So that's why.
No problem.
You weren't elected to anything in your absence, so you're okay. I forgot to worry about that.
Just a slight deviation from normal course of business because we have six members attending by teleconference and just Ms. Thornton and I present here in the normal business room. I'm chairing the meeting today, so the voice you hear on the line is mine, is Nicole Avers.
Thank you.
Okay. You're walking in on the election of the officers, and there was a nomination for vice chair.
Okay.
Can we have that nomination one more time?
Yes,
For-
this is Judge Hudson nominating Klein Lauterbach. Judge Kraft seconding.
Okay. Was there any opposition? Hearing none, I'm going to take a roll call vote. Judge Kraft,
Aye.
Judge Lauterbach, Judge Hudson,
Aye.
Judge Harvey, Stansel Ford, Linda Byford,
Aye.
Veronica Thornton.
Aye.
All right, we congratulate our new elected officers for 2016. Have the members had a chance to review the minutes from the December 4th, 2015 meeting?
Yes.
Yes.
Is there any recommendations for revisions?
Move we adopt the minutes as written.
I'm sorry, who recommended?
Judge Kraft.
Kraft.
There's errors in it. This is Judge Hudson.
I'm sorry, there's errors?
Yes.
Okay, can you specifically suggest where?
All right. Second line says Judge Kraft called the meeting to order. And then down about 10 lines it says Judge Lauterbach called the meeting to order. And I think he was called to order that day, or am I missing something? I think I did by telephone.
Okay, hold on a second. Well, let me get to that page. It does.
The second line, and then about down below staff members present, Judge Lauterbach called the meeting to order.
All right, we'll amend that.
And then on page 2,
Okay.
there was a motion seconded by Judge. That would be me, but that's misspelled. And the first vote.
Oh, I see it.
All right, that's what I saw.
Anything else?
No, ma'am. Madam Chairman, I move that we adopt the minutes as corrected.
All right. Is there a second?
Second the motion, stands for forward.
All right. Any oppositions? Hearing none, I'm going to call for the roll. Judge Kraft,
Aye.
Judge Lauterbach, Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stansel Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton.
Aye.
Motion passes as amended, or with the minutes as amended. The next thing on the agenda is the legal report. I'm going to turn this over to our stand-in attorney, Mark Green. Ellery Richardson has taken a job in a new department with Environment and Conservation. We congratulate her on her new position, and we will be getting new legal counsel very soon. In the meantime, we are in good hands with Mark Green.
Good morning. Thank you, Ms. Avers. As Ms. Avers said, my name is Mark Green. I'm Chief Counsel with the Division of Regulatory Boards, Department of Commerce and Insurance. I am actually filling in for Chief Counsel Tony Glandorf, who's filling in for Ms. Richardson, so I am like the third string. So hopefully we will get through this, and I will not make any errors that are too noticeable. The first thing, we've got two matters that we are going to do this morning on the legal report. The first thing is the legal report itself. There's two items. And the second thing is completion of the rulemaking hearing. We will have a summary of that. We will do the economic impact statement. We will do the Regulatory Flexibility Act as required by the statute, and we will allow for public comments prior to the council taking a vote on the rulemaking hearing. If you approve the rulemaking hearing, it will, or the rulemaking as adopted, this will be sent to the Attorney General's office for review prior to the adoption date of the actual rules as amended. I'm going to begin with the legal report. Have all the members present been able to review the legal report?
Judge Kraft, yes.
Okay. I will, since there are only two, I will do a brief summary of these and then ask for any discussion or motions as to how to dispose of these. The first matter is 2016-006321. The complainant alleged that an individual was attempting to administer probation with extortion and exploitation of illegal documents. The respondent is not a licensee of the council. The complainant appeared to indicate this person was a public probation officer. This matter was referred to the appropriate agency, who in turn communicated that the respondent was not a public probation officer. The respondent could not be located via telephone, and no address was given. There's no sufficient evidence in order to determine the facts of the issue or whether a violation occurred. Violation doesn't appear to be one. There's currently no rule allowing the council to intervene in a harassment or retaliation situation. There's no prior complaints on this individual, and it is the recommendation of legal to close the matter.
Hey, you've heard the recommendation. Is there any discussion?
Well, this is Judge Kraft. I move that we adopt the recommendation of Chief Counsel. I second. This is Judge Lauderback. I second this.
Who's that second?
Judge Lauderback.
Okay, thank you, Judge Lauderback. Is there any further discussion? Hearing none, I'm going to call for the vote. Judge Kraft?
Aye.
Judge Lauderback?
Aye.
Judge Hudson?
Aye.
Judge Harvey?
Aye.
Stancil Ford?
Aye.
Linda Byford?
Aye.
Veronica Thornton?
Aye.
Unanimous pass.
Thank you, Ms. Avers. The second complaint is 2015-02-16411. Complainant alleged that respondent private probation company officer threatened and required son to return to jail after being conditionally released in order to seek mental health care. An investigation was conducted. The investigation found that the complainant's son was released from jail on September 24, 2015, and was to report for mental health treatment immediately, and if not able to do so, to contact the probation officer. After release, the complainant called indicated her son could not be checked into the facility until September the 29th, 2015. The respondent then called the judge to determine clarification of the order. The respondent named the judge and indicated the judge stated his order was that if the complainant's son could not immediately check into a facility, that he needed to return to jail until he could be checked into the facility so that he was not a danger to himself. The respondent relayed this information to the complainant's mother, who was upset by this. The respondent received a call back later from complainant's mother stating her son attempted to hurt himself and they were at the crisis center. Respondent stated that the complainant's son needed to go back to jail after leaving the crisis center based on the court's order. Respondent contacted the judge again, who stated that the best place for complainant's son was back in jail until he could go to the mental health center. History, no prior discipline on this respondent, and it is the recommendation that there was no legal violation found and the matter should be closed.
This is Judge Kraft. I move that we accept the recommendation.
This is Judge Hudson. I second that.
Okay, you have a motion and a second on this matter. Is there any further discussion? Hearing none, I'm going to take the roll. Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stancil Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton. Aye. Motion passes unanimously.
Thank you, Ms. Avers. I will move to the rulemaking hearing. I'm going to read a summary of the proposed rules as drafted that the council has decided, I guess at its last meeting, is that correct? That to move forward on. I'm not going to read them verbatim or recite the entire rule. I'm just going to give a summary. I believe you all have copies of the proposed rule as it is has been amended, and then we will do the economic impact statement and the regulatory Flex Act analysis on the record as required. And then after that, we'll call for public comments. Yes, Ms. Avers.
Just so for the record, I want to make sure that everyone has it so that there's no dispute on the
Okay.
record. I just want to I'm going to go through roll and just make sure that each of you indicate that you have it. Judge Kraft,
Have it and I've read it.
Judge Lauterbach,
I've read it.
Judge Hudson,
Have it and I've read it.
Judge Harvey,
Have it and read it.
Stancil Ford,
Have it and read it.
Linda Byford,
I have it, and I've read it.
and Ms. Thornton.
I have it and I've read it.
Okay,
I didn't say I have it, but I have it. This is Judge Slaughterback. I just said I read it. I have it and I've read it.
excellent. All right, well done, everyone. Thank you. I'll turn it back over to you, Mr. Green.
Thank you. And prior to taking a vote to adopt the rules as proposed to proceed, we will allow for an opportunity for public comments so that prior to that vote, any member of the public, either who have sent statements in or who are present today who wish to make comment on the proposed rule may have an opportunity prior to it being voted and adopted by the council. Description of the proposed rule. We are talking about Rule 1177, and specifically 1177-2 and 117701. I did that not in chronological order, obviously. So it's 01 and 02 that we are talking about. These rules lower the quarterly provider fee that registrants must pay to the council from $1 per probationer to 75 cents. These rules also add a code of professional conduct and clarify that registrants are required to keep and post certain items they are already required to have, such as insurance, policies, and the fee schedule. There is also a new rule that registrants must properly supervise all probationers as required in the probation agreement with the court. The new professional conduct rules include the following. No registrant or employee may accept a gift, gratuity, or favor from a probationer, probationer's family, or any person with the intent of influencing a probationer's supervision. No registrant or employee may charge any fees not in the registrant's fee schedule unless ordered by a court or otherwise required by law. No owner or employee of the registrant may engage in a romantic or sexual relationship or have any sexual contact with a probationer. No owner or employee may use his or her supervisory position to encourage or otherwise force a probationer to engage in sexual activity. All registrants and employees must treat all probationers and members of the court in a professional manner. Unprofessional treatment includes, but is not limited to, engaging in abusive, aggressive, hostile, or disrespectful conduct, engaging in fraudulent or misleading behavior, giving any false impression of arrest authority, engaging in harassment or discrimination. That's the summary of the proposed rules. Prior to moving on to the economic impact statement, I'll ask if there are any questions or clarifications from members of the council. If not, I will move to the economic impact statement. Required by Tennessee Code Annotated Section 4-5-401. As part of the rulemaking process for any proposed rule that may have an impact on small businesses, each agency shall prepare an economic impact statement as an addendum for each rule that is deemed to affect small businesses, which shall be published to the Tennessee Administrative Register, filed with the Secretary of State, and made available to all interested parties, including the Secretary of State, Attorney General, and Reporter, and Government Operations Committees of the Senate and the House of Representatives. And as described for rules in Part 2 of this chapter, the statement shall include the following: the type or types of small business and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. And as such, legal has drafted that this rule would impact all licensees to the council regarding the fee reduction and also regarding the standards of practice. 2, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. And I'll say, if any members of the council want to add prior to adoption, as I read these, if you want to make any changes or have any questions about the statements that legal has prepared, please do so. These new rules require a licensee to maintain a license to maintain a schedule of fees and policy for indigent offenders, along with the proof of insurance. Such requirements are minimal in that they only reflect part of their current business operation and do not create any These requirements are not expected to create any new requirements on persons with professional skills, as no report is created. Number 3, a statement of the probable effect on impacted small businesses and consumers. The probable impact on small businesses is minor in that the record requirements are items that are part of the licensee's current operations. Consumers will be impacted little at this area of regulation as this area of regulation does not provide services to consumers but to persons on probation. However, such impact to those will include greater awareness of rates charged to the probationer and awareness to the licensee's policy regarding indigency. Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist and to what extent the alternative means might be less burdensome to small businesses. These rules are creating a less burdensome regulation by decreasing the quarterly provider fee from $1 to 75 cents. The record-keeping requirements are minimally burdensome. Standards of conduct are those standards that are not burdensome to accomplish. Number 5, a comparison of the proposed rule with any federal or state counterparts. There are no known state or federal counterparts to such rules regarding private probation services. Analysis of the effect. Number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Exemption of small businesses would negate businesses from being able to pay a less quarterly provider fee of 75 cents. Exemption from the record-keeping requirements would subject probationers to potential deceptive practices and hinder future investigations of violations of standards of conduct by the council. Are there any questions on the economic impact statement analysis? Finally, the regulatory flexibility analysis. Methods of reducing impact on rules on small businesses. Each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The agency shall consider, but not be limited to, each of the following methods of reducing the impact of the proposed rule on small businesses while remaining consistent with health, safety, and well-being. Number 1, the extent the rule may overlap, duplicate, or conflict with other federal, state, and local governmental rules. There will be no overlap in this rule, duplication, or conflict with other federal, state, or local government rules. Clarity, conciseness, and a lack of ambiguity in the rule. Number 2, the rules are clear in purpose and intended execution. The implementation of the proposed rule change will reduce ambiguity in the rules by clarifying some points. Number 3, the establishment of flexible compliance and reporting requirements for small businesses. These rules do not create any new compliance or reporting requirements. Number 4, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. These rules do not create any new compliance or reporting deadlines. Number 5, the consolidation or simplification of compliance or reporting requirements for small businesses. There are no new compliance and reporting requirements. Number 6, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. These rules do not set out operational or design standards. Any new performance standards would be related to the new conflict of interest or professional conduct rules. Registrants that conduct business appropriately will not need to change how they operate. Number 7, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase cost. It does not appear that these amendments to the rule will erect barriers or have other effects which would stifle entrepreneurial activity, curb innovation, or increase cost. In fact, these rules lower cost, which will hopefully encourage growth. That's the summary of the rules, members of the council. That is the economic impact statement read in full, analysis read in full, and the Regulatory Flexibility Act analysis also. Prior to entertaining any motions to adopt or amend, I will move to public comments. We did have one comment that was submitted to Ms. Avers' office, and that comes from Mr. Craig Turner from Memphis, Tennessee.
If you'd like, I'll read that into the record.
That would be great. Thank you.
Mr. Craig Turner wrote on February 15th, 2016 to the Private Probation Services Council. The enclosed proposed rule change is respectfully submitted for consideration. Sincerely, Craig Turner, General Manager of Correctional Services Incorporated, doing business as Tennessee Correctional Services in Memphis, Tennessee. Proposed change to Rule 1177-2.03, Uniform Contract Standards. It is proposed that the wording of Rule G be modified as follows. G. Procedures for handling the collection of all court-ordered fees and restitution for handling court-ordered community service. G. Part 1. No entity licensed by the Tennessee Private Probation Services Council shall accept payments for court costs or fines from persons placed on supervised probation or diversion by a court in in the state of Tennessee. Justification for rule change. TCA Title 16, Chapter 3, Part 9 does not address the matter of court costs or fine collections by private entities one way or the other. Therefore, there is nothing in Tennessee law to prevent a Private Probation Services Council from imposing this rule change. Furthermore, there is an increasing move in the United States towards encouraging courts to explore alternatives to incarceration solely for the failure to pay money, whether the failure is related to court costs, fines, restitution, fees, child support, civil judgments, utilities, taxes, or other legally binding financial obligations. Disputes over these issues has resulted in any number of lawsuits in recent years throughout the country claiming that such incarcerations are unconstitutional in that they essentially amount to a debtor's prison. No solution to these matters is offered here, but it is suggested that removing PPSC's licensed entities from directly accepting and processing court costs and fine payments would help ameliorate these controversies for PPSC licensed entities and would help the public better understand that PPSC licensed entities, by and large, perform an outstanding service for their clients, the courts, and the communities, at least as much, if not more so, than the state and county managed probation programs, and with at least as much professionalism, honesty, and integrity, and they do so with no taxpayer appropriated financial resources. Of course, PPSC licensed entities would still be responsible for monitoring the payment of court costs and fines to the clerk's office, since said payment is typically a court-ordered condition of probation. And that ends his written comment. I turn it back over to you, Mr. Green, if you have anything else.
Thank you, Ms. Avers. I don't know if the members of the council want to address that comment or call for any other comments.
I don't think that, this is Judge Lauterbach, I don't think those comments, they might be good, but I don't think they address our rulemaking change that we've got under consideration.
And this is Judge Kraft. If I could say this too, just so it's clear for the record. Yeah, that is that rule change would be in another section that we are not trying to change. I appeared 3 weeks ago in the legislature when one of the members of the Senate Judiciary was concerned because there's a current lawsuit against a private probation company, and he wanted to put the Private Probation Services Council on a sunset provision so they could check on how we are monitoring companies and things like that. And I pointed out to them that obviously that may be under investigation by the council, by the Department of Commerce and Insurance, that has not come before us, and that a lot of our companies do great work. A lot of counties have private companies that collect all their court costs, and it really does a lot of good for those counties. And I made that clear to the legislature, and I would think that if the legislature wanted to prohibit them from collecting court costs, they can pass a law to that effect. But I'm not sure that that's something that this council should be about, because a lot of the counties, particularly the poorer counties, they rely on these companies to collect their costs for them, and that's something the companies offer to do. So I'm not sure we need to get into that area. Even though it doesn't concern these particular rules here, I'm not sure we should get into that. That may be a matter for the legislature.
Judge Kraft, this is Veronica Thornton. I totally agree with you. And in addition to that, it's calling for regulation of the private probation agencies. And if it came down to that, I believe it should be left to the counties and the courts and the judges as to which services they need and that the private probation agencies can provide. If the legislature wants to pass legislation to prohibit it, that's another situation. But as far as this board regulating the agencies and preventing them from collecting for the counties, some of the probation agencies, that's the sole reason that they're doing business for some of the counties.
But there's there's a difference, but we've sort of gotten aside because this is not what your rulemaking change for today is, but there's a difference between monitoring whether the court costs are collected and being the actual person that the money's paid to, then in turn pays it to the clerk. And I personally have a problem with probation companies receiving the funds and then turning them over to the county. That's just
Yes, sir.
something I disagree with, and we don't do that here. And I just think that puts too much power in the hands of a probation officer to push somebody to pay the money. So you got to bring it here and pay it to me, and then he's trying to decide how he's going to portion that between what goes for his fees and what goes to the court cost. They can monitor that just as easily by saying, "Bring me your receipts."
Right, and of course and it depends. A lot of it is so county specific. I remember we were proposing regulation one time in one county, and they had two courthouses because there was a mountain in between, and so they're all different. And so I'm not sure that we should take this upon ourselves, but I'm sure the legislature is aware of the conflict situation. And when we were proposing these professionalism rules that we're adopting today, I don't think we contemplated basically passing a law forbidding counties from allowing their companies to do that. And I kind of agree. For right now, we need to leave it up to the local jurisdiction unless for some reason it gets to be a problem.
Well, for our purposes today, the only thing we have to consider is this proposed rule changes. And
right.
This other issue, something we can talk about maybe even later today, but for right now, we need to talk about voting on these proposed rule changes.
Okay, I'm gonna take the position back and call for the votes specifically back to 1177-01. Let's take it section by section, and then we'll do the economic impact and the regulatory flexibility. For chapter 1177-01. I want to get, do I have a motion to adopt that section?
This is the section that changes the fee from $1 to 75 per quarter.
Yes, that's right.
I move we adopt the rules as the rule. I move that we adopt the change in the rule as been proposed.
That's Kraft.
Judge Kraft with a second.
And
that was Judge Lauderback. This is Judge Kraft with a second.
Okay. Lauderback.
Judge Lauderback made the motion. Judge Kraft made the second.
And I'm going to call for the vote, the roll on this one. Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stancil Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton.
Aye.
Motion passed unanimously.
Ms. Avers.
Yes.
And I want to clarify, I originally said 117701 and 2, and it looks like there are several sections under 2 I didn't specifically mention, but I know you'll get to, but it is 1 and 2 that are being
Right.
amended.
I'm getting to 2 right now. Chapter 1177-2, there's a lot of parts under that. Would you all be comfortable taking that as a whole? Or do you want to go?
This is just Kraft. I would make a motion that we adopt those new rules as a whole.
This is Judge Lauterbach, and I second that.
Okay. Calling for the roll. Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stancil Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton.
Aye.
Motion passed as unanimous. All right. Moving on to the regulatory economic impact statement. Those as proposed by the legal counsel. Do we have a motion to adopt?
This is Judge Kraft. I move to adopt.
Judge Lauterbach, I second that.
Okay. Any discussion? Hearing none, I'm going to call for the roll. Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stancil Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton.
Aye.
Motion passes unanimous. All right, and then the last part is the economic impact statement.
I think that's the is that the
Excuse me, the
regulatory?
regulatory flexibility. Is there a motion to adopt the regulatory flexibilities?
So move.
This is Judge Lauterbach. I move we adopt the regulatory with what you just said.
Yeah.
Whatever the name of it is.
Flexibility.
Flexibility.
This is Judge Kraft. I second the motion.
All right. Any discussion? Hearing none, calling for the roll. Judge Kraft,
Aye.
Judge Lauterbach,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Stancil Ford,
Aye.
Linda Byford,
Aye.
Veronica Thornton.
Aye.
Motion passes unanimously. I believe that concludes our rule-making hearing.
And that concludes the legal report. Thank you, Ms. Avers.
All right, then the last item of business of the regular scheduled business is the director's report, which is very brief. On the director's report, I have the licensing counts for you. There are 37 private probation companies, 210 private probation officers. The revenue as of February 2016 is $62,331. The total expenditures was $7,180. There are no legislative updates as of this month. And that concludes the director's report. Is there any new business? Hearing none, is there a motion to adjourn?
So moved. This stands forward.
Before you do that, do we want to address the letter from Mr. Turner?
Yes, I can respond to him about that. Do you want to call it up at a future meeting to discuss his concerns for another rule? Or just address it?
If I can be heard on that too, in talking to some of the legislators, what they're doing is they are waiting on our probation council staff to finish their investigation on that one lawsuit and see what they find. That may or may not become before us. And then if there's a problem, I think the legislature most likely will make legislation next year on this. So what I would not like to do is for our council to take this up when that lawsuit that I've read about in the paper, I've not gotten any information from the Department of Commerce and Insurance, but when that may come before us, and I would hate for us to discuss and take a position on something that might come before us later when I think the legislature may want to address that issue by statute rather than by regulation, especially when we're talking about debtor's prison and constitutionality and things like that. That's just my suggestion, though. Obviously, Judge Library, if you want to address it in the rest of the council, that's fine.
That's fine. The issue we can take up later, whether we should do it now or not, is and whether the legislature should do it is totally different. And we should not be doing anything now. The question is, how do you respond to his letter? You said, new business. He wrote a letter, so you should respond the way Judge Kraft just said. Just tell him that it's pending. There's legislation. I mean, Judge Kraft, you can tell her how to respond. What you're trying to say there.
Yeah. Well, I guess basically we can't really. You know, I only know that there's an investigation going on because I read about it in Tennessean. But it's not a complaint that he's filing, but you can let him know that we discussed it in our council meeting, but at this point declined to make a rule. You know, there's several steps to the rule, and obviously we would have to publish it and everything ahead of time. So if you could just let him know that, I would appreciate it.
I will do that.
I just want to, this is Mark Green again, and I'm going to close on this unless there's any further legal questions. And I'll just caution the council, Judge Kraft, I know that you've had interactions with the state legislature as you have discussed. And
only publicly in the legislative hearing.
Sure, absolutely. I totally understand that. And I will just, as the lawyer, caution anybody, if you're asked about any case that potentially is pending towards the council, you know, you don't. You want to refer them to us. You want to, if any questions, if anybody asks you individually about any type of specific case or anything, you want to refer that to Ms. Avers in our office so that we can respond. Because the reason for that is obviously we want to maintain you know, the unbiased nature of you as the council, and you don't want to be predisposed to any information you might read and or see or somebody tells you about. Just please be very aware of that, and if somebody asks you specifically, just refer those to Ms. Avers and the legal counsel here at the department.
Yes, sir.
All right. Going back to the last motion on the books, is there a motion to adjourn?
Move to adjourn, Judge Kraft.
Okay. Any objections? Hearing none, we stand adjourned.
And their next meeting is when?
I think it's June
11th, June.
We changed the dates last time.
Yeah, it's the first Friday in June.
While we're on that, could you go ahead and give us the rest of the dates, please?
Yeah, we changed them to the first Fridays of every quarter, June, September, and December.
Okay.
June 3rd, and they're posted on the website under the public meeting notice.
Right, this was the second Friday because we had already posted a lot of things before we made the rule change.
That works. Okay.
Yeah.
We changed them all to the first.
Thank you.
That works then, first Friday. Thank you.
Okay.
Goodbye.
Goodbye.
Bye.
Thank you.
Bye. How will they?
Well, they have to go to the Attorney General's office.